Well, good morning, everybody. It's very nice to have you here, and it's a great pleasure for us to receive here at Direito GV, Professor Victor Ramhaj. That is, first of all, is a great friend, wonderful person that has been with me and Ronaldo at CTLS some time ago. It was a great experience, and that time we had the opportunity to get to know better Professor Victor Ramhaj, that has been dedicating his time to study transnational legal issues, and is probably nowadays one of the most important names in academics relating to these points. Just for you to know, Professor Victor Ramhaj is an associate professor in the Faculty of Law, National University of Singapore. So, and he's not coming from Singapore now because he's coming from Colombia. Yeah, he's a world citizen. And he has an LLB in Toronto and LLM at Queen's University in Belfast, and philosophy at McGill and PhD at Toronto. And he's a member of the Law Society of Upper Canada, Ontario. He twice served as the faculty's Vice Dean for Academic Affairs, 2006, 2010, and then 2011, 2012. And for 1 year, from 2010 to 2011, it was a co-director of the Center of Transnational Legal Studies, the center that I mentioned before. He has many papers and articles and books related to international law and transnational law. He is specialized in this area, and it's really, really a great pleasure for us to receive you here now. We'd like to thank you for coming to Brazil and for being kind enough to be here now and share with us your experiences with transnational law. His speech today will be related to transnational private regulation and domestic constitutional law. That's the theme that he's been working now, and it will be a book, isn't it? Yeah. So it's the seed of his next book, and well, now I'll let him present his speech now, and after that, it would be great to listen to the audience, and we hope to have a very nice time to discuss here. So thank you very much for being here, and the room is yours.
Obrigado, Francisco.
And he speaks Portuguese as well.
Bom dia. Desculpa-me por falar tão mal o português. And with that, I will turn to English. Forgive me. But as the talk goes on, if I'm going too fast or if you need me to stop and explain something a bit more slowly or carefully, please just raise your hand and let me know.
I would just suggest you to be very close from the microphone,
okay.
And you can take it if
Sure.
you want. If
Okay.
It's better just for the record.
No problem. Is this okay?
Yeah, it's okay.
Okay. So thanks, Francisco and Ronaldo. The three of us were at various times at CTLS in London. And in fact, it was that experience in London that led me to this project. I am, I guess, first and foremost, a constitutional lawyer and a constitutional theorist, and I've taught courses in public law in Singapore. I've published in constitutional law, and I've taught courses in comparative constitutional law. I did some work on emergency powers, and in fact, I'm very sorry that I have a book for FJV, which I left, very conveniently left at the hotel this morning, but I will pass that on to you.
Consider it.
Okay.
Yeah.
But when I had the opportunity back in 2009 to teach at CTLS, the Center for Transnational Legal Studies in London, it was a wonderful experience on many levels, not the least of which because it led me here and to your dear colleagues, but also because intellectually it was an awakening moment for me. I think as constitutional lawyers, probably more so than many other kinds of lawyers, constitutional lawyers are very much focused on the state and on state law. The Constitution is quintessentially state law. And when I went to London and started thinking about transnational legality, it made me question some of my assumptions as a domestic constitutional lawyer. And as I learned about different forms of transnational regulation, it made me ask myself why it is that constitutional lawyers, for the most part, don't think about these questions. And that has led me to this project, right, that question. So what I'm going to do is I'm going to start by telling you a little bit about the book project that this talk forms a part of. And then I will get more into the details. My focus for this talk will be on transnational private regulation, but I need to set the stage a little bit by telling you about the broader frame of my research. So let me give this a try. So the book begins with some assumptions. And the first is, and this will be familiar to most of you, that the orthodox, liberal goal of constitutional law is to limit the power of the state. I think that's fairly uncontentious, although at least in Asia, sometimes we question this assumption. But I think for the most part, for modern constitutionalism, there are other goals, of course. Constitutional law organizes the state, and defines the organs of the state, and so forth. But in terms of its normative goal, it's to limit the power of the state. So this is the first assumption. But then we see that there has been, particularly in recent times, a transformation in the nature of private power. And this transformation is important because it has removed private power from the complete control of the state, I mean, assuming it ever was, but maybe it's a matter of degree. So it used to be that the state could control private power, and now it seems that in many respects, with the rise of transnational, multinational corporations, private power is increasingly escaping the control of at least states acting individually. And then I also assume that there's been a growth in global or transnational regulation. So whereas the state used to be the focus of regulation, and particularly when it came to regulating corporations, it was state law that was front and center. Now it seems that there are many layers of regulation, and many of those layers are beyond the state. So we see the rise of transnational regulators. Now, making these three assumptions, the question that I come to is this: how do we make sense of constitutionalism, domestic constitutionalism, in light of these developments, right? In light of the second and third developments. So, in other words, if the goal, the historic goal of constitutionalism is to limit the power of the state, and yet the state is losing its power both to private multinational corporations and to transnational regulators, how then do we, as domestic constitutional lawyers, need to reimagine domestic constitutionalism to adapt it to these new realities? So that's the question that I have asked at the core of my project. Okay, so let me pause for a moment and just explain a little bit more carefully what I consider to be the assumptions of constitutionalism. Okay, so the first assumption is that private power is subordinated to public power. Okay, and so recent historians of constitutional law, and I have in mind someone named Christopher Thornhill, has just published a book talking about the history of constitutionalism in Europe. And his argument is that he takes a broad look at European constitutional history, 400 or 500 years of history, and his thesis is that it's a history of the gradual subordination of private power to public power. And the culmination of that, I argue, is the rise of modern constitutionalism with the French Revolution, the American Revolution, right? So we see this shift, and public power becomes paramount. And there is a constitutional bargain here, right, which is that in exchange for the subordination of private power to public power, the state agrees to be bound by the Constitution, right? So theoretically, that's one of the ways, theoretically and maybe even historically, that's one of the ways of thinking about the rise of constitutionalism. Another assumption is that there's a vertical hierarchy of law within the constitutional state. And we can contrast this to the state of affairs in many parts of the world, including Europe and Asia, before the rise of modern constitutionalism, where there was a vast amount of legal pluralism, where there are many actors, not just political state actors, but many actors, religious institutions, merchant guilds, and other bodies that generated legal norms. All right, so we think back, there's a lot of discussion these days about lex mercatoria, right, which was a law that was apart from the state in those days, and of course religious law and even admiralty law. Many of these areas of law worked beyond the boundaries of the state, because the state was not the modern state in the way we think of it today. But today, with the assumption of modern constitutionalism, is that law takes this hierarchical form, and this hierarchical understanding of law militates against legal pluralism. Then the third assumption of modern constitutionalism is that there is a tight nexus between constitution and territory. Okay, so with the rise of modern states, we come to an understanding of law that says that each state has its own constitution, that state law is dominant, it's the principal form of law, and that any other forms of law among or between states is a product of the consent of states. And so law becomes gradually more and more territorial. So this is the history of modern constitutionalism and the assumptions that come out of that history that I think are under threat with the developments that I spoke of earlier, right? The rise of transnational private power and the rise of global regulation. Now let me just give you a little bit more about my book, and then I'll focus in on the chapter, the couple of chapters that I want to speak to you about today. So in the book, I go back to the history of company law, and in particular, the history of the East India Company. Now, I'm not sure the East India Company, I'm talking about the English, which later became the British East India Company. I'm not sure how familiar it is to you, but I spent some time talking about it. This is one of the first merchant empires, private merchant empires, that started in the United Kingdom in 1600. Around the same time, the Dutch East India Company came into existence, the VOC. I won't even try to say it in Dutch. My Dutch is worse than my Portuguese, believe it or not. So the English and Dutch East India Companies start trade with Asia. And I talk a little bit about that history, and in particular, the British East India Company ends up exercising sovereign-like powers in India, and gets into a struggle for power with British Parliament. It's a very interesting story there about the tensions between state and company and the different ways in which the East India Company served as, or acted as both a state at times and as a company at others. And then I talk a little bit about the history of constitutional law. I look at the resurgence, what I call the resurgence of private power, as multinational corporations become stronger over the course of, say, the last century in particular, but I focus on the recent period. So that chapter gets into that history, and I will talk a little bit about that today, because I think it's not just the rise of corporations, but we see lately some interesting developments in terms of state capitalism and in terms of arbitration, international commercial arbitration and investor-state arbitration. So I'll talk to you a little bit more about that today. I'll talk a little bit more about Chapter 4. The focus of this talk will be on Chapter 5, which is global regulation, in particular transnational private regulation, but I will talk more generally about the rise of global regulation. And then the last two chapters of the book begin a rethinking of domestic constitutionalism. Okay, so this is an outline of the project, and like I said today, I'm going to focus mostly on these 2 points and give you a little bit of a hint as to where I'm going in my rethinking of constitutionalism. Okay, so this lecture, what are the implications of the rise of global companies, the emergence of transnational regulation for domestic constitutionalism? That's what I'm going to talk to you about today. It's a very short version of this bigger project. Okay, so we're already 15 minutes into it, and I've just finished my introduction, but I promise you I will be done in the next 40 minutes or so, and we can get into a discussion. Okay, so a bit more details in terms of where I'm going in this talk. I spoke about the rise of private power, but I suppose that's a little bit misleading, because it's not just private power. And as we've seen, and I suspect this is also the case in Brazil, although the poster child is really China. We've seen the rise of state capitalism, right? So I'm going to talk a little bit about multinationals. I'm going to talk about state capitalism and private dispute resolution, the rise of transnational regulation, and then transnational private regulation, which provides the means for securing public goods and values that are typically guaranteed under international law, but also challenges domestic constitutionalism both in theory and practice. Okay, so that's a more detailed summary. Let me get into the talk itself. Okay, so in terms of recent transformations, an important transformation has been the changes in multinational corporations, and historians of company law talk about an important transformation from the 1990s onward. Okay, and this is with the Washington Consensus and the mobility of capital. And what we see is this is a professor at SOAS in London, Peter Machlinski, and he talks about the adoption of truly global production chains by multinational enterprises and their associates, and a marked shift from raw materials and manufacturing towards service-based FDI. Now, I know many of you are more knowledgeable about this than I am, and I hesitate to speak of such issues at a business-focused law school. I know most of you are very well schooled, but and you may want to contest this, but I think we have seen an important transformation. I mean, we can see it even in recent news events, right? So. The factory collapse, the Rana Plaza factory collapse in Bangladesh several weeks back, right? We can see how multinational corporations, their supply chains, their production chains stretch around the world, right? we only need to think about our daily interactions to think of the ways in which multinational corporations act almost seamlessly around the world. And this includes, I would say, law firms, right, which are now trying to provide their services on a 24 hours, 7 days a week, around the world basis, right? So you walk into the door in Sao Paulo and you get the same kinds of services as in London or New York or Singapore. This is the aspiration of law firms, but it's also the aspiration of many businesses, and it's in many respects the practical reality today. So we have seen a transformation, right? And it's fueled by technology, it's fueled by transportation that allows me to fly from Singapore to Sao Paulo. This is the global economy, right? Now, I'm not going to spend much time on this because I'm assuming most of you are convinced. If you're not, that's okay. We can talk about that later. But let me go on. I think more interesting, perhaps, and maybe more contentious, is the rise of state capitalism. Now, this is an interesting statistic. I don't know if you saw this article in The Economist. It was about a year and a bit back. It was on state capitalism. And it had some interesting pictures and flags, and among them were Singapore and Brazil. But again, as I said, China is probably the poster child here, and state companies in China make up 80% of the stock market value. It's the highest, and Brazil is not quite as high. I can't remember now. Maybe some of you know, but it's quite high, right? And this seems to be a very common model in developing economies. And frankly, I mean, we can make a historical argument that the East India Company served a similar role. Even though it wasn't a state company, it eventually came under the control of the British Crown and Parliament and provided an economic engine for the British state to develop. And you could say the same thing about the VOC. In relation to Amsterdam as a city in the Netherlands, right, as a state, right? So we can see the importance that some state control over companies plays in terms of development, and we're seeing this today. Here's an interesting statistic. It's about a year old, and there's a revised one. But in 2012, okay, on the global Fortune 500 list, the 500 biggest companies in the world, 61 of them were Chinese companies, and of those, 59 were state-owned enterprises. Okay, so that just gives you a sense of the sheer magnitude, right, of state control over the corporate world. And then another aspect of state capitalism, which is very close to me in Singapore, is sovereign wealth funds. Okay, and I'm not sure if Brazil has one. It's probably based on oil revenues. Yeah, and of course many oil-rich countries, and frankly provinces and states. So I'm originally from Canada. My home province is Alberta. And the city where I grew up is Calgary, which is at the heart of Canada's oil industry, right? And Alberta, the province, has its own sovereign wealth fund, right? And has had for decades. Alaska has one. Norway has one. But many of the sovereign wealth funds are based in the Middle East and in countries like China and Singapore. So Singapore has a couple of massive sovereign wealth funds. And these sovereign wealth funds play an incredibly important role. So, I mean, you can see the statistics. I looked it up, and I think in 2013, today, this was a projection, but I think in 2013, they were estimated to have between 5 and 6 trillion US dollars under management, of assets under management, so it's a massive amount. But during the financial crisis, when Citibank was sort of on the financial brink, Singapore's sovereign wealth fund and Kuwait's stepped in with a 25%, taking a 25% stake in Citibank in order to prop it up. And for some, this was a key moment, right, in preventing another domino from falling, right? And then this was done in discussion with the U.S. government and so forth. So sovereign wealth funds are playing an incredibly important economic and political and diplomatic role, right? So these are examples of a set of important transformations. And so when I started this project, I would talk about the resurgence of private power. I think it's probably better to talk about the resurgence of corporate power, because the corporations can be both public or private, right? So what we're seeing when we talk about multinational corporations, global corporations, is global corporations that may or may not be state-controlled or state-owned. But the change then is a change in the nature of the transnational nature of these corporations and the extent to which they've grown so dramatically over the past few decades. Okay, so we've seen a couple of key changes that may be of concern. A third one is this, that along with these changes, right, along with the growth of commercial power, we see the rise of international commercial arbitration, private arbitration, right? Arbitration typically between two major multinational corporations that's conducted not through state courts, but through private international arbitrators. Okay? I'm sure you are all familiar with this phenomenon, but I think it is conceptually very important. This is an old statistic. I'm going to have to revise it. This just gives you a sense of how things change. This is from the UK, 2010, and between 2007 and 2009 in London, and remember, this is during the financial crisis, right? There was a 59% rise in the number of cases that were subject to international commercial arbitration. Now, I've looked at other figures. I don't have them on these slides, but if you look around the world, if you look at Singapore, you look at Dubai, you look at China, Hong Kong, international commercial arbitration, ICC in Paris, so there's similar stories, right? You see the chart, and it just goes up, up to the right. And that's the story everywhere. So we see major venues in the big commercial centers around the world. So with the rise of global companies, we've also seen the rise in international commercial arbitration, the privatization of dispute resolution, and what we might see as the loss of state control over the development of commercial law. Now, of course, some of you might say, well, okay, this is all fine, but this is all with the consent of states, right? Because if it weren't for the New York Convention, right, we couldn't have this. Well, that might be true, but the reality is that something like 90 to 95% of all cases are settled, are voluntarily complied with. You get your award, and it's complied with, because it's in the interests of these actors not to have to then go to the state system to enforce their awards, right? So in some ways, it takes on a life of its own. Okay, and then the other development is, apart from international commercial arbitration, is investor-state arbitration, right? All of the bilateral and investment treaties and international investment agreements, right, that allow foreign investors to take states into arbitration, right, to protect their investments and basically raise states to the level of companies that put them on equal par. They level the playing field so that, some would even say that they tilt the balance in favor of corporations, right, because foreign investors now can take states to court when they try to regulate them in such a way as to threaten their investments. Okay, so these changes, I suggest, are changing the nature of not only the global economy and the role of corporations in the world, but they have important implications, as we'll see, for constitutionalism. Now, what I want to talk about now is how states and other actors might respond to these developments. Okay, so the first point I want to make is that we can try to use traditional legal tools. And I want to talk about what we might call state-centric tools. So thinking about traditional state law and interstate law or public international law, and how these areas of law can respond to these changes. So the first, I call statist methods. The first of these statist methods is extraterritorial legislation. Okay, and here's an example, anti-corruption laws. Okay, so in the United States, there's now the foreign, so that should be CP, Foreign Corrupt Practices Act. Forgive the typo, which seeks to project U.S. law abroad. Right? Say, if you are a U.S. company and you are operating abroad and you try to bribe a foreign official, we can call you into the U.S. courts. It doesn't matter if your activity takes place overseas. Okay? Now, there are all kinds of examples. This is actually a really growing field in itself, is to understand the extent to which domestic legislation is now being projected abroad. Okay? And it's not just in corruption laws, it's in banking laws, it's in human trafficking. Yeah, yeah. So there are all kinds of ways. The Dodd-Frank, yes, exactly. So there are all kinds of ways in which domestic laws are being projected abroad. Now, of course, this is not, this is controversial, right? Because the reality is that it's the stronger states rather than the weaker states that can do this. Right? And maybe, I'm not sure that this is the only reason, there are all kinds of reasons, but you might all be aware of this recent case in the United States, the Kiobel versus Royal Dutch Petroleum case, which dealt with the Alien Tort Statute, the U.S. statute, which seemed to allow foreigners to make claims in the United States about acts overseas in contravention of international law. Well, the U.S. Supreme Court has tried to roll that back and say that there's a presumption against extraterritorial application of this statute. Now, that doesn't end the story, but there are issues here, and some of them have to do with politics or comity among nations, but the reality is that this option is not available to all states. It's available to powerful states, and the United States, among other countries, continues to try to extend its legislation abroad. But in terms of sort of a holistic, broad-based solution to some of the problems we were talking about, to the extent that corporations abuse their newfound powers, I'm not sure that this is necessarily the best answer. Okay, well, what about public international law, right? This is whenever there's been, whenever there's an international problem, right, what do we as lawyers tend to look to? Well, we look to public international law. Right. So why can't we do this? Well, in terms of formal law, we all know, and especially our international law colleagues will tell us, that it's no easy feat to come up with an international treaty. And even when we do, enforcing that treaty is a problem. I mean, consider, for instance, the multilateral agreement on investment. Right? This is something that's been in the works for decades, but again, there's no movement, right? Because of geopolitics, right? Because it's very difficult to get everyone to agree on the principles governing foreign investment. Okay, so we're left with, say, bilateral treaties. It takes a good 20 years, if you're lucky, right, to get a treaty signed by a sufficient number of states. So, I mean, I don't mean to suggest that public international law doesn't do good things. It does, right? We're all aware of the good that's come out of public international law and human rights arenas and elsewhere, but I think as a a solution as a holistic solution, as a comprehensive solution to the kinds of problems that arise from the rise of transnational corporate power. I'm not sure public international law on its own can be a solution. We do, however, see initiatives like John Ruggie's UN Guiding Principles on Business and Human Rights. Okay, now this is another way of doing it. Rather than going the conventional formal route, right, and negotiating a treaty, you can do it informally. You appoint a prominent professor to come out with a set of principles, get those principles to get governments and industry and civil society groups to sign on to the principles, and then find different creative ways of enforcing them. Well, that's certainly an option, right? And we'll have to see. This is fairly new territory. There was the UN Compact before that, but this is new territory, and maybe we'll see some good come of it. But again, this is international soft law, and it may link up to some of what I'm going to tell you about in a moment. But for now, this is new territory. We also see what we might call intergovernmental networks, and some of you would be familiar with Anne-Marie Slaughter's work on the New World Order, the way in which governments work together not formally, but through bureaucratic connections, right? So bureaucrats in, say, the Ministry of the Environment work together to coordinate policy. Or central banks, and this is a great example, right? Central banks work together to solve a financial crisis. Or intelligence agencies work together to share information in relation to counterterrorism or international terrorism. Okay, so we see these informal governmental networks, right, helping governments to work together to solve problems. So that's another route, okay? I mean, it's not always accountable in the same way, right, as formal laws, because you don't always have formal legislation or formal processes for scrutinizing these kinds of networks. And so they might work well in practice, but they may not work so well in terms of democratic theory and accountability, but that's another route. Okay, so these are the options that fall broadly within sort of state-centric models. Now, what I want to suggest to you, and this is getting into the heart of the presentation, is that we are now seeing some very different kinds of options. And I'll start first with hybrid arrangements. Okay, so these are arrangements where you see public and private actors working together to solve a problem. A good example is the Better Factories Cambodia program, which in about a decade or so ago was concerned with factory conditions, working conditions in Cambodia. So as Cambodia emerged economically and politically from decades of isolation and political violence and instability, started to look towards trade, and one of the concerns was that there were all kinds of sweatshops, as we call them in English, right? Places where people work hard, the conditions are horrible. And so the US government, in signing a treaty with, a trade treaty with Cambodia, decided to tie increases in the quota of garments that could be exported to the United States to improvements in factory conditions. So that was one step. And then they brought in an inspectorate to work on, to go into the factories and inspect to make sure that they were complying with standards. And this was done as a pilot project with the International Labor Organization. So you had state arrangements, you had an international body. You also had the Cambodia government who worked with the factories and passed legislation to say that only those factories that complied with the inspection program would be entitled to any increases in the export quota. So you could only increase your access to the US market as a factory if you complied with the inspections. And then the factories themselves signed on to this program. So it was this sort of multifaceted regime for trying to improve labor conditions. Now, I've only started to look at the response to the Rana Plaza disaster in Bangladesh. But you can see similar initiatives, and in fact, there's an NGO in Washington, I can't remember the name, that seems to be driving some of the corporate responses, right? The corporations who have said, we agree to put money into improving factory conditions, and they signed a compact. Well, that was initiated by a civil society group in cooperation with the Bangladesh government and other groups, and I think the ILO was involved as well. So we see these initiatives, right, that are multifaceted. We have different kinds of standards being articulated. We've got organizations like the Fair Labor Association involved, but we have basically private NGOs, governments, and industry working together, right, to find problems, creative problems, to solutions to these kinds of problems. And this matches nicely with some of the initiatives in Europe, right, to do something similar. So in telecommunications and in other areas, you see this sort of co-regulatory triangle, regulatory triangle involving government, industry, and civil society, right, working together to regulate. And you have regular meetings with these three groups to try to work out different kinds of standards. So and this is increasingly being recognized through formal processes and formal law. And I believe the Lisbon Treaty makes formal reference to co-regulation, but I stand to be corrected on that. At least indirectly recognized. Okay, which brings me now to transnational private regulation. So this is a term that's now, if you do a search, right, you'll see this spike in the number of references to transnational private regulation in the past few years. There are various groups of researchers who are working on it. There's the Kafagi and company working at the EUI. There are other groups who are looking at this. I mean, it's you can call it by other terms, but the current term is transnational private regulation, or TPR, right? So if you see TPR, that's what it's referring to. But the idea here is that you have not intergovernmental bodies, not governmental bodies, completely private bodies that have no formal links to government that are regulating different industries. A few examples just to get you thinking about it. Forestry Stewardship Council. Right. So this is a group that tries to promote sustainable forestry. They have a set of guidelines. They have a governance structure that involves different bodies from around the world. They generate norms, and they license their label, the FSC label, to companies that follow their standards. Why do they do this? Well, because a lot of companies believe that because of consumer pressure and consumer practices, that consumers will buy green products, that they associate the FSC label, right, with sustainable forestry, and so they're willing to pay money. And companies believe that if they adapt their practices to make sure that they comply with FSC standards, right, they will benefit in terms of market share. So it's a market-driven regulatory initiative by a private body to promote sustainable forestry. Okay, so that's one example. Many of you would be familiar with the International Organization for Standardization, the ISO, right, which also promotes standards, and companies see a practical benefit in ensuring that their processes conform with ISO standards. And then there's also, those of you who do IT law will be familiar with ICANN, the Internet Corporation for Assigned Names and Numbers. So if you want your domain name registered, you have to go, I mean, there's a contracting out, so there are different, within each state, there are different bodies that will conduct the formal registration, but ultimately it's all done through the ICANN, which is a private organization registered in California, and yet it regulates domain names, URLs around the world. Okay, so another example of a private, transnational private regulator. There are many others, okay, many others, and there's a lot of work being done just in keeping track of them. Okay, so back in the early 2000s, John Braithwaite and Peter Dreyhus at ANU, Australian National University, came out with a book about this thick called Global Regulation, right? And they started to give the examples, to show how this was happening across industries. There are others who are working on this. It's not just lawyers, it's political scientists, it's public policy people, and so there's a lot of work just to keep up, just to try to enumerate, to identify all of the bodies that are involved. I was at a lecture in Singapore a couple of months ago, and someone from Europe was giving a talk on these kinds of initiatives, and he gave the example of the airline industry. And there are so many different organizations, whether it's groups of engineers or working on particular issues relating to safety. There are just multiple layers of regulation, and this kind of private regulation. Right, it's sometimes done through industry associations and so forth. The International Accounting Board, I can't remember the name of the organization, but there's another example, right? A private organization that is effectively regulating accounting practices around the world. So there are lots of examples, and I'm sure many of you can think of others. Okay, so. So with the rise of transnational private regulation, we have both opportunities and threats. And especially, I'm thinking about this now from the perspective of a constitutional lawyer. So let's talk about these. Okay, so opportunities. Well, here's, I think, the greatest benefit of these kinds of organizations, which is that it allows well-meaning groups of experts, civil society experts, to step in and regulate when states are unable or unwilling. Now, I'm not sure the story is accurate in all respects, and maybe some of you would know this, but the Forestry Stewardship Council, if you look at the history of that organization, it was founded in late 80s or 90s in response to deforestation in the Amazon. And the concern was that governments at various levels were unable or unwilling to step in, and so a group, an NGO, said, we're going to do something about this, and they founded the FSC. Okay, so a good example, right? Now, they might be founded in other ways, but many of these organizations have the potential, right? I mean, the Kyoto Protocol, right? The climate change framework falls apart. Well, what happens? Well, we see NGOs coming up to the plate and trying to get involved in this way to promote standards, transnational standards, right? Using whatever devices, whatever kinds of enforcement mechanisms they can. And it doesn't have to be purely market-based, right? It can be reputational. Public international law has long used shaming, right, as a strategy, and we see this in transnational regulators. So although it's not a private regulator, but the Financial Action Task Force, which was a G8 body, a committee of the G8, right? And its aim was to regulate anti-terrorist financing. What they've done is that they produce country reports on an annual basis setting out how well a particular country and its financial institutions comply with its guidelines, right? In much the same way that formal international organizations produce reports, right? And the last thing you want as a financial institution in a country is for your institution or the country in which you're operating to be named as one of the countries or industries that fails to comply with the Financial Action Task Force's guidelines on anti-terrorist financing. Right? That's a major badge of shame. Right? So these organizations do have tools that they can use to enforce their standards. They're not the typical tools that states use, but they're still effective tools that they can use. Right? And so they use markets, they use shaming, and they use other kinds of strategies. Okay, so in terms of opportunity, with the rise of global corporations, we see the correlative rise of transnational regulators, including private regulators, that are using these tools, stepping in when states are unwilling or unable to act. But of course, there are also threats. One obvious threat is, where do they get their legitimacy? Nobody elected these people. Nobody put them into power. They are, in some respects, self-appointed regulators. Right? They've decided, I'm going to regulate this industry. Well, where do you get your legitimacy? I mean, at least with states, with some states anyway, we can see some form of democratic legitimacy. Or even if it's not formal democratic legitimacy, there's some element of popular support, right, that can that gives the state the legitimacy in regulating corporations or other individuals or their activities. Well, again, the private regulators are aware of this, and they have strategies. Right? So among their strategies is their governance structure, and many of them, in their governance structure, will have the involvement of governments as representatives, not controlling, but giving their views. So they'll have government, industry, and other civil society representation from around the world. And so these different constituencies will have an overall governance or supervisory role in relation to the activities of these companies, like a board of directors, a big board of directors. And they also, when they generate norms, when they generate their standards, many of them will use a notice and comment procedure, right? So they'll publish their draft guidelines, put them out on the internet, right? Give a period of time in which people can comment, receive comments from around the world, all kinds of individuals or organizations, take those comments on board, and then revise their regulations or their guidelines in light of the feedback. Right? So again, an instrument that's used by state regulators, but an instrument or a method which enhances their legitimacy. But still, there's a concern about accountability. Ultimately, to whom are these organizations accountable? And of course, they can promote their own agendas. They're looking at a particular concern, and there may be other concerns, other areas that they're not as interested in. And so either by design or accident, or because of their particular focus on their particular industry, there may be cause for concern that there will be abuse. So if you have, for instance, a financial regulator, like say the Financial Action Task Force, which is trying to prevent terrorism financing, you might have a collision between its goals and, say, privacy concerns. And so unless someone is looking at those privacy concerns systematically, right, there is, again, potential for abuse. Okay. So this brings us to domestic constitutional law, right, and the challenges that these developments pose. So let me try to put this into perspective. The first concern is that Many states are increasingly unable to regulate MNCs, multinational corporations, and for that matter, also private regulators, right? So I'll come to this in a moment, but of course, it's not just that multinational corporations are escaping the ability of states to control them, but also private regulators, which are operating on this broad global scale and exercising a form of private power, although it's debatable whether it's a private power or public power. We'll come to that. As we saw in the context of arbitration, state law is increasingly marginalized in the resolution of commercial disputes. So we have another form of isolation of the state or separation of the state from its ability to regulate transnational corporate power. And then we see the blurring of the line between states and companies, which I referred to earlier when we were talking about sovereign wealth funds and state-owned enterprises, and between public and private. So we see states acting as regulators of, actually that should be private power, right? This is the traditional role of states, regulating private power, but also wielders of private power, right, in the form of state-owned enterprises, sovereign wealth funds. And we see non-state bodies, right, acting as both wielders of private power in the form of multinational enterprises, as well as regulators of public power through transnational private regulation. So the world is getting more complex, and it's getting more complex from the point of view of constitutional law. So just a few suggestions. And I'm starting to get into the last two chapters of the book, so this is just the big principles that I'm trying to work with. So the first, what does constitutionalism need to do? Right? How does it respond to this these very difficult challenges? Right? This transformation in the landscape that constitutions are trying to deal with. Well, the first thing, I think constitutionalism needs to openly acknowledge constitutionalism. Okay, so I'm talking about constitutional courts, constitutional actors, constitutional lawyers, constitutional law professors, right, in a very broad way. So let's call that constitutionalism. Needs to acknowledge the blurring of the line between public and private. We can't go on pretending, right, that they're neatly separated, right, and that the state regulates private power, and that it's all very straightforward and simple. Okay, the world is much too complex for that, as I suggested in the last slide. Second, I think we need to rethink, now this may be a very particular point that may not make as much sense in some constitutional contexts as others, but let me explain it, and then maybe I can ask you later whether this makes sense in the context of Brazil. So constitutional lawyers need to rethink the state action doctrine and apply constitutional norms to private actors. Now, in many of the jurisdictions that I'm familiar with, whether it's, say, the United States, Canada, Singapore, and some others as well, constitutional principles apply as between private actors and the state. Right? So the private actor can complain, an individual, or sometimes a corporation can complain that its activities, its constitutional rights have been violated by the state. Right? So it's a vertical application of the Constitution to prevent the state from abusing its power relative to individuals or corporations. Right? But in some jurisdictions, and notably South Africa, but as I learned a few days ago in Colombia as well, there's a growing tendency to apply constitutional principles horizontally. I think there's also some basis for this in German jurisprudence, but horizontally, right, as between private actors. And that may be where we need to go in terms of constitutional thinking, right? Because It may be that a private actor or a notionally private actor is exercising public-like functions, right, in trying to regulate, and in so doing, violating the rights of another private individual. So I think we have to get past the idea that constitutionalism applies only vertically and think of constitutional principles being relevant as between private actors acting in whatever capacity, but particularly acting in a public regulatory capacity. And then finally, I think we need to loosen a link that I was talking about before between constitution and territory, and just putting the last 2 points together. So if you have a transnational private regulator that affects the rights of an individual, right, a private individual, so let's say it's some private transnational actor operating sort of seamlessly around the world, maybe based in London or Geneva, is creating guidelines which are regulations that then affect a citizen of Brazil in Brazil. It may be that citizen can seek to apply constitutional principles to constrain the activities of the transnational private regulator operating outside of Brazil. Right? So in some respects, it's a private-to-private action. It's an action between two private individuals, but it's invoking constitutional principles, right? In a way that doesn't focus solely on the territory, the relationship between constitution and territory, because you have a transnational private regulator that's seeking to operate around the world seamlessly. So I think we need to loosen this link, right, between constitutional jurisdiction and territory. And that is a very, well, not so brief, but that is a snapshot of what I've been working on. And I'm curious to hear whether any of this makes sense to you. And the reason I wanted to come to Brazil and also Colombia, and I've been presenting my work in other places, is because in the work that I do in constitutional law, comparative constitutional law, and I write in English, I'm afraid. I do read a little bit of French, but I tend to publish in English. And often the audience, the scholarship that I engage with, and the audience that I often have in mind is a very North Atlantic audience, right? I write in Singapore, and so I have my audience in Asia as well. But much of constitutional law scholarship written in English is very North Atlantic focused, right? It looks at issues from a particular perspective. People are talking to one another. And in my work, I try as hard as I can not to do that. And believe me, it's hard. Especially, it's hard when you're as linguistically challenged as I am. Right? I'm trying to learn a little bit of Mandarin. I speak French. I have limited access to other languages. But I think there's a real danger that in our work, in our research, that we try to make broad theories or try to see our principles as operating around the world, but then we draw on examples that are only from a small number of countries, and we say, okay, well, on the basis of these examples, we can extrapolate to the world. And I don't want to do that. I don't want to make that mistake. Now, it's hard to be completely universal in our research, but the main reason I'm here is to see if any of what I'm talking about here makes sense to you, whether it makes sense in the context of Brazil or Latin America, whether the project that I'm engaging in is a project that is worthwhile from your perspective, and if it is, whether you can help me think through some of the examples that you've encountered. So I don't mean to preempt. I'm honored that some colleagues are going to have a few thoughts for me, and I hope we can get into a discussion. But I would like to hear what you think about this project and whether it makes sense or whether I'm off on some tangent that has no bearing on the issues that you confront today in Brazil and the realities of your legal world. So thank you very much for your attention, and I look forward to your questions and comments.
Thank you, Victor, for your challenging lecture. It was really great, and I'm quite sure that your lecture brought some doubts and questions for the audience. So I would firstly open the floor to professors that are present, and I would ask you if one of you would like to be the first, and any one of you would like to comment something? Ronaldo, please go on.
Well, thank you, Francisco, and thank you, Victor. Wonderful and very thoughtful presentation. I'd like, actually, I don't know if I have any really smart comment to make, but I have some questions. I'd like to hear more about some of these issues. Well, first of all, you mentioned what is strikingly interesting in your presentation is that there are many dimensions of the whole framework that you offered us. I mean, there are some theoretical challenges, there are some empirical dimensions, and in many ways, and that comes to my first question. I wonder if, considering the way you make the whole picture, the very complex picture, and you use this idea of complex, that the world is becoming more complex, I wonder if the very line, I mean, the very border of constitutional law is somehow being challenged by what you said. I mean, I was thinking whether what was the main point of your presentation, whether it would fit to law in general, to global law in general. What is the specificity of constitutional law that you are trying to call our attention to? I mean, of course, you mentioned blurring the lines between private and public law. But what, in your opinion, is really specific to constitutional law? And this leads to my second question, which is, you started by saying that traditional constitutional law is very much linked to this idea of controlling the state power and limiting, and in somehow a new way of conceptualizing law itself. I wonder if, where would you put the issue of democracy in your framework? Because constitutional law is also very much connected with the protection of political rights. And especially, and this comes to my reaction, especially, I believe, in Latin American countries, and this is certainly true in Brazil, constitutional law and the new constitution is very much connected with our fight for democracy. Of course, this is not the case of constitutional law in Singapore, for example. This is not really the major issue there. But I would like to know more, what are your thoughts about how to connect this protection and this dimension of protecting political rights and constitutional law, which is one of the most traditional areas of constitutional law here in Latin America. And a third question connects me to the issue of constitutional interpretation. I mean, what we have been experiencing here in Brazil, and I would say generalize this argument to Latin America in general, is what we sometimes call the new constitutionalism. I mean, the openness to more, to give more relevance to the kind of principiological interpretation of constitutional law, which have some ambiguity and sometimes gives a lot of more discretionary powers to our judiciary, but on the other hand, it also gives a much more flexible way of interpreting constitutional law. So I'd like to know more, how do you frame this idea of what is the impact on constitutional interpretation according to your view? And finally, I'd like to, there has been quite some kind of revival of the law and development concern in Latin America recently. And one of the ideas that are very much connected with this revival, it's not the revival of the old-fashioned law and development that was thought in the United States during the 60s and 70s. So you're trying to it's a kind of reappraisal from the very basic assumptions that were there in the old law and development. But what is now trendy, what is now fashionable, is to think about this new developmental state, and then, which is a new kind of arrangement between state and market, which is not only connected. Of course, it's very much closely connected with what you describe here. I mean, this new role of state and private actors, but it's more than that, in the sense that it's a kind of specific kind of arrangement, a specific kind of way by which you can make these connections, putting much more relevance to a new way to organize this regulatory state. So I wonder if how do you react to this new movement? And you know, I'm sure you are acquainted with some of our common friends like Carrie Ritish, for example, and David Kennedy and many others. Some of them will be here on Monday discussing this. There will be a meeting discussing this issue. So I wonder how do you connect this constitutional dimensions and this new developmental state that is on the rhetoric of the law and development scholars now?
Okay. So thank you so much. That is. Those questions in themselves are worth the price of admission. So thanks. That's really interesting and really provocative. Okay, let me take the questions in turn. And the first question: how specific are the arguments I'm making to constitutional law? So I think. I mean, it's clear that law across a number of fields is becoming much more transnational. And I think we can see it. I mean, if you're an environmental lawyer, right, you probably shrug your shoulders and say, well, none of this is new to me, right? I mean, the transnational nature of environmental law, I think of it as, maybe this is not right, but I think of it as one of the most transnational fields. I mean, it's just the nature of environmental law and in particular, you know, climate change. These are very international fields. Francisco, when we were in London together, presented a paper at a colloquium on bankruptcy and cross-border insolvency. And then there's another field where it's harder to just think purely in national terms. But I think why my field, or constitutional law, is specific and is challenged perhaps to a greater extent is because modern constitutional law, right, if we look historically from the American and French Revolution to the way it's developed, is almost identified with state law, right? So you wouldn't necessarily say that environmental law is identical to state law, or that bankruptcy law is identical to state law. But it's, I think, at least in our traditional understanding, it's hard to think of constitutional law as anything but part of state law. Oops, running out of battery power here. Okay, I'll just shut down. I've got, yeah, no, it's fine. Now, let me just say, though, that this too is changing, right? And there has been a growth lately in scholarship on both global administrative law, right, and global constitutional law. So taking traditional domestic constitutional principles and transposing them to the supranational level. And so people talk about the WTO as having an informal global constitution, or they talk about the constitutionalization of the UN, and so forth. I want to do something different, right? Because I think that's important work, and I think it links to what I'm trying to do. But I think what gets lost in trying to take constitutional principles and projecting them to the supranational level is how domestic constitutional law responds. So I think, at least in terms of my work and what I'm trying to do, I'm not saying it's completely unique, and there are a handful of people who are looking at this, right? But compared with the people who are looking at, say, global administrative law and global constitutional law, this is a fairly specific area. Very few scholars are pausing to think, what are the implications of these transnational developments for domestic constitutional law? And so domestic constitutional law, the idea of the Singapore Constitution or the Canadian Constitution or the Brazilian Constitution, people don't think about these issues. Right? And so I guess that's a long answer to your question, but I think that that's why I think this is sort of a very there's a very specific element to what I'm trying to do that distinguishes it from other areas of law. So I hope that sort of at least begins to answer your first question. So your second question was about democracy and how this fits with the protection of political rights. And I actually would link this to your third question about constitutional interpretation and the emphasis on principles, right? And so we think of the Constitution, the articulation of constitutional principles as protecting individuals, protecting them in particular from abuses by the state, and this is linked to our idea of a liberal democracy. On the one hand, it's linked to our understanding of the role of a constitutional court in articulating a set of principles that protect the individual from incursions by political power. So this is all important and still important and will continue to be important. But I think in some ways to think of it as the exclusive concern of constitutional law is problematic, because the threat to individual liberty, the threat to individual rights, labor rights, political rights, is caused not only by the state, but by private actors. And that is the argument that I'm trying to make, right? That we can be concerned with freedom of speech, we can be concerned with freedom of association, we can be concerned with all of the classic liberal rights, but these rights are not violated only by the state. So I'm not suggesting that somehow we throw out all of the principles, the classic liberal constitutional principles, or the interpretation of those principles. What I am suggesting is that we have to think of them more broadly, and we have to think of the centers of political power more broadly. Right? It's not just the state. I guess that's what I'm trying to argue in the project, is it's not just the state that poses a threat to individuals or organizations within its borders, because the nature of power is changing. And if, as constitutional lawyers, we hold on to the view that it's just the state that is of concern to us, then we're missing the bigger picture. We're missing out on the radical implications, right, for constitutional law of these broader transformations. So that's how I'd answer both your second and third question. Law and development revival, I have to say that I'm not as familiar with this literature as I should be, and maybe after this we can talk some more. I wish I had been able to sit in on your seminar in Singapore and learn a bit more about this. But it does remind me of some of the discussion on the East Asian developmental state, and even the discussions in Singapore. And it does tie in, I think, to what I was saying about state capitalism, right? So I think in much of East Asia, corporations have played an important role in economic and therefore political development. I think it's, again, important to recognize this, that the state can guide economic development. It can do so in the interests of economic, sort of political development as well, that the two can go hand in hand if managed carefully. But this emphasis reinforces my concern about the blurring of the boundaries between states and companies. And it goes back to what I was saying. I didn't talk about this, but the second chapter of the book looks, I think I told you about this, it looks at the East India Company, right? And I think it's important to see how there can be both a tension between state and company and sort of a mutuality of interests between state and company. And we saw this in the history of the East India Company, but it may be that as economic and political power become closer, as states and companies become closer, no one's left to guarantee that individual rights are not abused, right? Because if the state, take international commercial arbitration, for example, right? Many states are promoting international commercial arbitration, right? Because it's in their economic interest, or in the case of Singapore, Singapore wants to be seen as the major place in Southeast Asia for international commercial arbitration. So the state is completely behind the development of this area of law. Yet what happens is that the state is basically saying, we're going to privatize the judicial function, right? And if it does that, then there is a growing coincidence between political and economic or commercial power. So who's left? And that's where I think private regulation might come in, or other forms of, or other NGOs have to step in and start playing the role as protectors of constitutional rights, right? Because the state might not always be in the interest of the state to do so. The state might, because it's so interested in economic or commercial development or developing its companies, it may not have the political will to then say, oh, at the same time we're going to constrain the very companies that we're trying to empower to drive the state economically. Okay. I hope that answers your questions. Yeah. If not, we can come back.
Well, Victor, first of all, congratulations for your presentation. It was very interesting. I work with Ronaldo in TPR project with CAFAD, so we're very, we know a lot of things about this, and we're trying to help CAFAD with Latin American case studies. Okay. I also work with another student here, Alexandre, in a IOSCO regulation. This is a international organization with security regulation. Okay. And I think we have a case study here, very interesting, or connected with your theoretical work. And after 2008, after financial crisis, the executive compensation became a very important issue. And CVM, our Securities and Exchange Commission, we had a new rule complying with the international standards, saying that now we have to disclose the executive compensations. And so we have internalized international standard by our bureaucratic agency, by our regulatory agency. And some private actors here in Brazil, executive association, use the courts to don't comply with these international standards, saying or arguing that this standard is against the privacy right that it is in our constitutional act. Okay. So when you're asking in a theoretical level, well, constitutional right is important. It is interesting to get a broad notion of constitutional right. I can also agree with you, but then what this case suggests is that maybe the local actors, they are interested to use the local institution to don't comply with international standards. So that's not just a meaning of have a broad sense or not, but it's how the interested use the institution, local and international institutions to don't comply with it. So it's a very interesting case to show that maybe there's a lot of other things to consider in this theoretical view. And also another student here is working with international arbitration and how they use the Supreme Court to don't internalize the award. So listen, because here we have a constitutional article that says that nobody can enforce or exclude to go to the judiciary, the right to go to the judiciary. So if something that in the international commercial costumes, they used to do something like that. And then when they came to Brazil, and then the Supreme Court said, no, it is against our constitutional. So now it's another case that the local actor used the constitutional to don't agree or don't comply with the international standards. So maybe it's not a meaning just to have. It's not just a juridical matter. It's just they have other things involved.
Thank you very much. And that first case that you mentioned is exactly what I'm looking for as I go into my chapter 6, right? Because the next chapter, after I get to this stage, so my next question is, how have domestic constitutional actors in practice responded to these challenges? And I've been trying to find cases, and there are very few. So I'm delighted to hear about this case, and I'm going to, has it already been determined by the courts?
No, it is in injunction.
Okay.
But since our judiciary is, a low, with low, so maybe we have 10 years with this decision.
Okay, so for the next 10 years, I'm going to be very interested in following what's going on. But I would like to get the details. Yeah, because I mean, one of the cases that I came across in Canada, this very different field but similar kind of issue, in 2010. Vancouver, you might recall, held the Winter Olympics. And before the Games were held, the International Olympic Committee decided not to hold one of the women's ski jumping events. And this decision, this decision was then binding on the Vancouver Organizing Committee of the Olympics. And so a group of women ski jumpers challenged the decision not to hold the event in court in Canada as a violation of their Canadian Charter of Rights and Freedoms right to equality. And so this decision went to the courts. Now, it's a very sophisticated decision, but it sort of has a number of different tiers. But in the end, the way I understand the court's ultimate decision is it said that the International Olympic Committee is a private entity, right? It's in a private contractual relationship with the Vancouver Organizing Committee, and they effectively denied that they had jurisdiction to deal with this. So to me, it's a similar kind of situation. You have what's considered a private body, international body, making a determination, and the court's refusing to apply domestic constitutional principles, right, to limit the power of that private entity. I'm curious to see what happens in this case, because it seems to me this is a very similar kind of situation, right? And to what extent are the Brazilian courts going to say, well, yes, it's an international body, but it's exercising what's effectively a public regulatory function, and it's doing so with an impact in Brazil on Brazilian citizens' rights. And so are the courts going to say, we have jurisdiction, and it doesn't matter if it's a private body or some transnational body, private or hybrid or intergovernmental, we're going to assume jurisdiction because we need to protect the rights of Brazilian citizens. Now, I would be more interested to see whether how they decide on jurisdiction than on the substance, right? Okay, so they might say yes or no on the privacy right, the right to privacy. But whether they think it's even fairly within their jurisdiction, I'm curious to see how they decide on that question, because that's ultimately what's of most interest to me in this project.
Thank you, Professor Viviani. Fortunately or unfortunately, I think you'll find plenty of material about that. Salem want to talk, and Mario Engler, and then Rodrigo. So Professor Salem.
Well, you may have precluded some of my questions by answering to Ronaldo, but I will put them anyway. But just let me start with this last example, since it's a discussion, an open discussion. What came to my mind in this moment is I don't think the example of the Vancouver thing is the same as the IOSCO example. There you can say we don't have jurisdiction because it's a contractual thing between privates. They are free to do what they want, right? It's the autonomy of their will. So it's one explanation for the... Here, the IOSCO makes non-mandatory recommendations. The body that finally produces the regulation is the Brazilian body. It's not bound to do so. It does so because it thinks it's a good policy, right? So it's regulatory action that goes under the control of the Constitutional Court or the Brazilian courts. And it is this regulatory action by the Brazilian body that will be denied effect because it's contrary to our constitutional principles, privacy. So I think when we think of the steps, it's not anymore the regulation that is produced by IOSCO, a hybrid body, that is under discussion in our constitutional setting. It is the regulatory power of a Brazilian institution. When you think of the relationship, it's, well, there is this production made in the international arena. It's not mandatory. We choose to adopt it or not. When we choose to adopt it, then our regulatory activity is under control by the judiciary. So sometimes I think it's less mysterious than we imagine at the beginning, right? So I will put my questions in some dichotomies that I think help me understand this theme. I think there's one fundamental dichotomy that is the difference or the separation or the distinction between law and non-law, right? Law and something called generally regulation. Not in the sense of the administrative regulations that is the specific meaning, I think, in English, but I'm thinking more of regulation in a very generic sense, right? Regulating by rules, by norms, human activity. So is there a separation, a distinction, a difference between what is law, legal regulation, and non-legal regulation, or regulation more generally speaking? This dichotomy, I think, is fundamental, and it helped me understand or state a second dichotomy or the second relationship between constitutionalism and legal or regulatory pluralism, right? Because you said in the beginning that traditionally we make some assumptions about constitutionalism. It's subordination of private powers, hierarchy and verticality of law, nexus between constitution and the territory. But I was thinking, well, is there a necessary nexus between constitutionalism and legal regulation, in the sense that it has to be law, or may it be non-legal regulation, right? Does constitutionalism and constitution relate also to non-legal regulation, or does it relate specifically and exclusively to legal regulation? And the other assumption that I think we usually make, I think we make the assumption usually that it relates to law, it relates to legal regulation. And the other assumption is that that Constitution relates to a single, to a unique, cohesive legal system, right? So when we think of not only of territory, but we are thinking of the Brazilian legal system when you are talking about the Brazilian Constitution. So the relationship that you are trying to establish, to me, reads as trying to establish relationship between the constitutionalism that is thought of as belonging and directing generally the legal system, specific legal system, domestic state legal system, because this is what, and an environment of legal pluralism and of regulatory pluralism, right? Now, this pluralism that you are talking about, it's not any pluralism. It's not domestically circumscribed. It is a transnational legal or regulatory pluralism, right? So why did I say that you may have precluded my questions, is that I was going to go towards international, transnational constitutionalism, global administrative law, etc. But you have limited it to the domestic. The other dichotomy that I think may need some deepening, at least for me, I felt this need. When you speak generally of private power, you speak of the power of the corporations or corporate power, and on the other side, the regulatory power of the private institutions or bodies, right? When we read the title of your presentation, I was thinking mostly of the regulatory power of private bodies. But then you make a strong point towards there is a transformation of the corporate power. And this distinction does not really appear completely clear to me, how we want to control the corporate power, private power, or do we want constitutionalism to control private regulatory power? Because I think these are two very distinct issues, no? Well, I will not go into the discussion of the global administrative law, but in general, when I try to understand this, is that global administrative law is, let's say, the diagnosis of global administrative law is that there is a need for an emergence of global administrative law because we already have a global regulatory space. And the regulatory space is, the regulation of this regulatory space is produced by several kinds of bodies that you have presented here, the hybrid bodies, the interstate, the private, purely private, etc. And the issue with this administrative law would be we have to have control mechanisms for this production, right? So maybe we will not have a global or transnational constitution, but we will have mechanisms of control of administrative law, of public law, or constitutional law that will serve as control mechanisms for this regulatory power that private or hybrid bodies have. So we will have concerns of legitimacy, accountability, transparency, right? Attention to stakeholders' interests. But it's not necessarily constitutional, but it is administrative law, public law, control mechanisms, right? Which usually we think of as being maybe the main objective of a constitution, that is control or organized power. I think it's organizing power before controlling power. If it is a rule of law constitution, then it controls power. And the other, as I understand it, the other great thing that constitutions do is recognize values or recognize fundamental rights, protect these rights. So these are basically the two functions. And there is a difficulty to see this appear in the international, transnational sphere, right, as such. The question is that if it does appear, does it relate to specific legal systems, for example, public international law, or, I don't know, European communitary law, or does it not need to be linked to a legal system? Or can we think of constitutionalism, not the national ones, right? Not the national one, but the constitutional effort or exercise, not linked to legal systems, specific legal systems, but maybe to legal regimes, right? Do we have this pluralism of constitutions? Can we, is this the, but since you have limited your scope to what happens to domestic constitutions, my doubt is, can really domestic constitutions deal with this task? Can they really answer to this, right? For example, when a couple of examples appeared, I think, well, it doesn't really appear to me as domestic constitutions or exerting some kind of control over this regulatory production that takes place. And also when you speak about arbitration and the privatization of the administration of justice, I don't see this example as really being the example of privatization or relinquishing by the state of its powers, because in reality, arbitration, commercial arbitration, is very much regulated by the state, and at the end, at the final point, it always depends on the state law to be effective and to produce effects in some territory, right? But my final and fundamental doubt, as you spoke at the beginning about the problem of extraterritoriality, and you said basically this favors only the powerful. When domestic constitutional law will start exerting control over private, transnational, hybrid regulation, will it be only the powerful states who will be able to do that and not the others, right?
Wow. I will answer all your questions in 1 minute.
Well, this is, as you may understand, this is the beginning of a long conversation that we will have during a long time.
Excellent, excellent. So yes, no, no, yes, and no. Okay, that's fantastic, really fantastic. And I will just start to answer some. Thank you. I'll just start to answer some of your points, and yes, I hope this is a long conversation. Well, I got my hopes up and then you shot them down, because if the case that we were talking about, the IOSCO case, was ultimately grounded in the actions of a Brazilian agency, then it's not helping me to make my argument. And frankly, it confirms my concern that most domestic courts are not prepared to directly take on transnational regulators, I've sort of thought of some examples, and I have yet to find a really good example of actually in sports law. Sports law we sometimes see domestic courts taking on transnational private-like regulators, like the FIFA and some of those other. That's actually the area where you can find some examples, right? Maybe because sports is so important. I mean, I would like, I'm going to continue to look, because even if the examples aren't there, my argument is that they should be, right? Okay, but so that's just on that preliminary point. Yes, I think on what I take to be your jurisprudential point, I think that's bang on, right? What is the relationship between law and non-law? And my argument is that we have to be willing to look to informal law and not just concentrate as domestic lawyers on formal state law. So I know that gets us into murky territory. I know it gets messy, but that's okay. I'm willing to go there, because to me it's not so much the formality of the law that matters as its practical impact, right? Through informal regulation, as we're starting to see, private regulators, non-state regulators can have an enormous impact, right? And it may not be direct. It may be that private actors and even lawyers, right? So I'm talking to some lawyers at the big firms in Singapore. They say, well, you know, when we advise clients, we don't just advise them on formal state law. We advise them on international best practices. We look to these standards, and then they advise clients, and those clients respond. So there is an impact. And so if we want to sort of be a bit more realistic, not just say, okay, well, what's the formal law? Okay, these are not binding laws. But if we look at their impact, if they have in practice an impact, then I think as constitutional lawyers we need to be concerned. And we shouldn't hide behind the formality or lack of formality, right, of these regulations. So I'm willing to accept that this might have implications for the lines between law and non-law, between law and religion maybe, right? I mean, what is international Islamic finance, right? Where does it come from, right? It's not generated by the state. Who are the experts, right? And yet, it's having an impact, right? And if you go and consult experts, those experts may have no relationship to the state, right? So we have to be willing, I think, to look at that as important non-state-centric regulation that has an impact on the way domestic actors, banks, individuals conduct their affairs. And I think the constitutional courts have to be willing to consider this as part of their purview. I've sort of written all over the paper. Yes. Okay. So your point about corporations and regulators. Yes. Because I'm talking about the book, and then I was trying to limit it, I ended up realizing, no, I can't actually limit it just to transnational private regulators, because I also have to talk a little bit about companies. And I guess my short answer to your question is that as companies become more powerful and states are unable to regulate them, then private regulators have the potential to regulate companies and to perform some of the role that states have traditionally played, but at the same time, they become centers of power in their own right that then need to be constrained. So the state might have an interest, in part, in having private regulators regulate companies in ways that they can't, but they also need to be concerned that private regulators can, in themselves, be private actors that abuse their own powers. So that's kind of the short answer to that point. Global constitutional law, I love the idea, and I've sort of thought about this in similar fashions, constitutional pluralism of constitutions. I think that's exactly it. So just as we see a multiplicity of regulations, a multiplicity of different centers of power, I think constitutionalism is also multi-tiered, multifaceted, right? So we see constitutional orders ultimately, ideally, complementing one another, but there is this sort of attempt to say, well, where do the boundaries of domestic constitutionalism and say the beginnings of the boundaries of global constitutionalism begin, or global administrative law, or regional human rights law? There are a set of instruments that are working together, right, to fulfill a similar kind of function. And so yes, I'm completely with you on that. My interest is in trying to understand how domestic constitutions fit in that broad frame of constitutional pluralism. Thank you. There's much more to say. It wasn't 1 minute, but you know.
Thank you. Professor Mario Engler, please.
Thank you, Professor Hamrajad, to share with us your thoughts. And I have a short comment, perhaps not a bundle of questions. You mentioned state capitalism. I'm particular interest in that issue, and also state-owned enterprises. And you mentioned en passant, actually, that sometimes the state performs two different roles, the same person actually performing two different roles, as a regulator and sometimes as a party in a commercial agreement, or as a controlling shareholder of state-owned enterprises. And perhaps you could elaborate a little bit more about that issue. And we have in Brazil many examples of state-owned enterprises, actually our national oil company, Petrobras, performing some state functions in Brazil, domestic, and also abroad. Some investments decisions took by Petrobras perhaps were not oriented by a commercial reason, but more by a political or state policy reasons. And perhaps if you are interested about that examples, we could talk later on. Thank you.
That's great. Thank you. Thank you very much. Yeah, I think this is an absolutely fascinating area, and that's why in my first substantive chapter, after my introduction, I go back to the East India Company, because I think many of these issues are very, very old. The sort of the relationship between the state and commercial actors. When is the state acting in a commercial capacity? When are its commercial interests aligned with its political interests? Does it act purely in commercial terms, or is there a sort of a diplomatic policy, political agenda behind? These are the East India Company, the history of the East India Company is just rich with all of these kinds of examples, which is why I'm going back to it, because it was a time when the modern state was not yet fully formed in the way that we think of it today. And so I guess one of the broad historical arguments that I'm trying to make, and I'm not a historian, but maybe a theme rather than an argument, is that just as we saw through the 18th and into the 19th century, the consolidation of state power in the modern state, and the sort of the state rising above private powers. Now we seem to see the unraveling of that, right? So that the state is now losing its powers to commercial entities, and but you know that's neither here nor there. As far as the question you asked about the state playing two roles, I guess I'm ultimately concerned that when we're talking about multi-billion-dollar kinds of corporations and the state having an interest in those corporations, it's not clear to me that the state, I mean, I know there are different branches of the state, and I know we can't think of the state in monolithic terms, and there are separations of powers, formal and informal, and regulators can act in one way and the state-owned companies can act in another. But ultimately, when you're talking about the most powerful commercial interests in the state, there must be a conflict of interest, right? When the state is trying to regulate the companies that are making it economically powerful in the global scene. I mean, look at the financial crisis and the willingness of the U.S. government, right, to bail out its biggest corporations, right? I mean, this is a country that is the poster child for capitalism, and yet it steps in. It was painful, right? But it steps in and says, too big to fail, right? So if that's the case, is the state really able to, on the one hand, play the role of the regulator, and on the other hand, play the role of a state-owned enterprise or be the controlling shareholder or what have you, right? There has to be a coincidence of interest, and it makes it more difficult for the state to play both roles. Those were the 2 points. The historical point, I think this is back to the age of those grand merchant empires, and so we're seeing many of those similar tensions between two large centers of power. I mean, some of you may not know that the East India, forgive me if you do, but the East India Company for depending on how you count, for at least 100 or so years, was the de facto government of India. Right? It was a company government. And that was what caused a lot of the problems and tensions, right? That the tension between the government and Parliament trying to control the company saying, oh no, we're just a commercial entity, but meanwhile having its own army and its courts and its tax collectors and the rest of it in India, right? So it was a really interesting conundrum that in an age where the modern state was starting to evolve, you had this company that was basically running India. And of course, then there was a rebellion in 1857, which ended up being the demise of the company, and the British Crown exercised direct control over India, right? And Queen Victoria became the Empress of India, right? In the stroke of a pen, and the East India Company was dissolved. But it was a really interesting historical time. And so when we think about these issues today, what are Chinese companies doing when they say go into Africa, or Canada for that matter? I don't know if this must have made the news here, because I mean, I'm sure there's some interest in the petroleum and energy industry, but the Chinese National Overseas Oil Company, CNOOC, just a few months ago received a green light from the Canadian government to buy an energy company in my hometown, Calgary, in Canada. And it was a $15 billion transaction, the largest acquisition of a foreign company by a Chinese state-owned enterprise ever, right? And so with that acquisition, it now controls a lot of the Canadian oil fields, Gulf of Mexico, North Sea. I mean, it's fascinating how these kinds of companies are playing an incredible role internationally. And of course, in Canada, there is a lot of pushback because they're saying, oh, what about environmental concerns and what about regulations? And the CNOOC says, no, we're going to run Nexon as an independent company, there's a slip of the tongue, company, and we're going to abide by Canadian regulations and so forth. But we're starting to see how state and company are starting to blend and raising these kinds of concerns.
Now, please, Professor Rodrigo Brolha Mendes from USP.
Thank you, Sachiro. Thank you, Professor Ramraj, for the wonderful lecture and the good overview of your book project, and a wonderful description of, I think, one of the main concerns in legal thought today. That's how we're going to cope with such a hierarchical way of regulate issues in globalization. Thinking about your presentation and thinking about the examples that you gave about transnational private regulation, I came to my mind the history of Lex Mercatoria and the revival of Lex Mercatoria, and I think it is a good example of could be the relation, or the tension between state and private corporations. I think when the Lex Migratoria revived on the 60s and 70s of the last century, the big concern about private companies is because they are entering into agreements with states to make the reconstruction of Europe, and the private companies are not willing to submit themselves to the state law from that state. So because the state could try through legislation protect their own parochial interests. So the war, or the key word to start to bypass such a problem was we are trying to resolve disputes, settle disputes, applying principles generally accepted by the civilized nations. And that is at least Bertolt Goldman, one of the most renowned jurists on Lex Migratoria, tried to make the case for Lex Migratoria. And today when we see Lex Migratoria, is a little bit more complicated than that, because it's not just a law made by professors, but it's law made by professors, made by professional associations, and I think there is no longer a concern that we're going to limit the power of state. I think they are more focused on the issue itself that are going to regulate. I gave you, for instance, the example of the letter of credit regulation made by the International Chamber of Commerce, which I think is a de facto standard for letter of credit in the world. And I think in this particular case, a constitutional concern rises, because if you see the Commission within the ICC, which proposes and regulates the letter of credit rules, they are basically formed by the banks. So that gave rise to the concern that Ronaldo raised the first time about democracy, who are participating in the production of the rules in private transnational regulation. So seeing that, I do see a lot of constitutional concerns in private legal regulation, private transnational regulation. For instance, in corporate governance, code of conduct, how we're going to cope with child labor, labor that was reduced as slavers, and so on and so forth. My question is more in the sense that Salin raised to you, is that when we see, and I'm not that familiar with the discussion, but when we see the discussion of global constitution, and it seems that we are not any longer discussing about who are the institutions that are responsible to protect constitutional concerns, but the interplay between a lot of institutions. So you mentioned in the paper that you have circulated before your presentation that you want to understand how the domestic constitution as a node for the broader picture can react to these constitutional transnational concerns. So my question to you is maybe something that has come up with me, is that does it make sense to understand constitutionalism as, in a pluralism way, as a real network of institutions, and to use your term node or not, domestic constitutional courts being just one node that react to pluralism, to real global constitutional concerns? And if that's so, constitutional courts or constitutional concerns are reacting in some way the parochial interest of private power. So they are trying to protect their own regulations. And in doing so, you see a change of methodology, and going to the question that Ronaldo raised about constitutional interpretation. I think that really demands a change of how constitutional lawyers interpret constitutional concerns, and not just the constitutional rules, because I think that the production of norms in this context is very different, and I don't think that we really understand how such norms come into force in this kind of a hierarchical production, saying that you mentioned in your paper about Annie Marie Slaughter, the wonderful books about the new legal order and the community of courts. Is domestic constitutional courts and domestic constitutionalism is being actually not just domestic, but being part of a great project of being a network of constitutions? Is that my question? And if that is so, what is your reaction to that? Thank you.
Very interesting points, and actually I agree with everything you said. I think that's exactly what I want to do. Now, my focus is on the domestic side, but yes, I mean, I've used in the manuscript, I've used, you know, a node, sort of a constellation of constitutional orders. You can use different metaphors, but I think that's right. The only point I would add to what you said, because I think all of your questions, I would just say, yes, I agree, right? But I think the one qualification that I would make is that I don't think it's coordinated, right? That's the thing. It's happening in a very piecemeal, reactive fashion, right? And I guess what I'm trying to do is to try to figure out one piece of the puzzle and then ask that question, how does it relate to all of these other pieces? Towards the end of chapter 7, I'm still writing those chapters, and into the last chapter, this is where I'm going. I'm going to start say, okay, once we start understanding how domestic constitutions react, the next step is to see how they fit with all of these other enterprises, right? All of the other forms of public regulation at the supranational level, at the regional level. How do we make sense of it? And that's, I mean, I've bitten off a lot more, as we say in English, bitten off more than I can chew, right, in a sense. It's a huge project. It's maybe ridiculously, stupidly ambitious, but, you know, I don't want to do everything. I want to raise some of the issues. I want to generate some general principles for how I think we can approach this, and then try to ask the very questions you're asking about how it relates to these other public law orders. So we're seeing pluralism not just in terms of the regulation side, the lex mercatoria side, all these other actors, but we're also starting to see the constitutional pluralism, right? The constitutional institutional pluralism. And I think maybe the next book or the next project will be trying to see how these pieces fit together. But for now, my focus is on the domestic side. Yeah. Domestic in quotations, because you know, what is domestic anymore?
Thank you. I'd like to give the opportunity for the audience to make any questions. I would suggest to you to, if who wants to make any questions, just show me, and then all of you do make your questions, and then you answer them as a block. Okay. And I brought a plan of paper, lots of papers, and yeah. Oh, there, the one. Yeah, please use the microphone. Yeah.
Hello.
Please identify yourself.
Hi, my name is Olavo Bernardes. I'm not a student here, but I like constitutional law so much that I decided to come, and I'm working on a PhD in constitutional law as well. My question is, I'm trying to become a constitutional lawyer and had the opportunity to study constitutional law in the US, where I lived for many years.
Where did you study?
I lived in Miami, in the University of Miami. But my question is, do you believe in a set of, it's a question that I always pose myself, do you believe in a set of international human rights in the sense that those human rights are above national constitutions? And do you think those human rights, because many people, you see many African countries and Muslim countries, that you have those sort of traditions, like for instance, cutting clitoris, the women's clitoris, and the international community condemns that. And then they say, no, listen, this is our tradition, and those sorts of international human rights are European-based or US-based, and you're trying to force your traditions into us. And I would like to know, how do you feel about that? Do you feel that there are international human rights that are above national constitutions, that they're above local traditions, and can they be enforced? Thank you very much.
Anyone else? Yes, Alexandre.
Professor, first of all, thank you very much for your presentation. And my name is Alexandre. I'm a student of Master in Law here. And my question is about international financial crisis. How do you think or consider about extraterritoriality of the European Union financial laws and American laws in the context of the environment of the international financial crisis, as the USA and the European Union are trying to regulate more and more their own financial systems? Do you believe that third jurisdiction, for example, Latin America, countries may or not be affected? And then if yes, how this effect could be? And for example, in Brazil, in terms of the financial rules, capital market rules, for example, we believe that derivatives rules, for example, may be negatively affected in Brazil because we have some positive aspects of the derivative regulation in Brazil that America, for example, the United States are trying to solve. And in Brazil, we believe some lawyers specialized in this field that it's more regulated or that's a better environment than the US, for example. Thank you.
Thank you. Shall I take those two questions?
Would you prefer? Well, we have a last one, and then.
Okay.
Could you use that microphone?
Hello, I'm Amelia. My background is in business, but I had a PhD in social history at USP. I'd like your comments, please, on the...
Could you please talk close to me? Yeah.
Oh, you are.
Yeah, just for the records. No, yeah.
Okay. About the so-called risky agencies like Standard & Poor's, Moody's, and so on, and I mean particularly...
Sorry.
They are called, I guess, risky agencies. They rank investments and countries and companies.
Yeah.
Okay, so
Yeah.
Standard and Poor's and so on.
Got it.
And particularly the point that they, I guess, they had their reputation harmed despite the now common knowledge that they had failed totally to in their ranks or their assessments, just in face of the financial crisis. Thank you.
Is that okay? So,
Okay.
please, Victor, it's your word.
Okay, is it Mr. Bernardes? Bernardes. Yes, so thank you for that question. It's kind of a loaded question, right? Because, you know, we talk about torture and all kinds of human rights norms that it's hard to say, no, I think torture is a good thing. Or but, so, I mean, do I believe in international human rights? I find that a very difficult question to answer. I mean, personally, I think all of the activities that we're describing, torture, genital mutilation, those kinds of things, I think are wrong. They should be prohibited. That's my personal view. But on the other hand, after living in Asia for 15 years, I've become much more hesitant to be an absolutist, because I think that it's hard to separate the substance, right, of a human right from the process through which we enforce it and dynamics of power, political power, right? I think a lot of what is presented as international human rights often has a particular geopolitical agenda behind it, and so I'm often very skeptical. Right, I'm skeptical. And there's a lot of misinformation. So I remember after spending several years in Singapore, and then I went on my first sabbatical abroad. And I have an American colleague who'd been in Singapore for ages, and I'm often very critical of the Singapore government and some of what it does and the courts and so forth in Singapore. And so my colleague said to me, you know, when you go abroad, you're going to find yourself defending Singapore. I thought, what? Because I've always been quite a critic of the Singapore government, a lot of what. So I went abroad to Belfast, Northern Ireland, on my sabbatical, and I remember at one talk, I found myself saying, but you don't understand, because you know, Singapore's not exactly the way you portray it, and there's this, that, and the other. And then I sort of remembered what my colleague had said, and I said, yes, I understand what you mean, because people make assumptions without really understanding the context, without really understanding what happened. I mean, Singapore executes drug traffickers, right? And yet, if we think back about the history, and I'm not excusing this, but if we think back to the Opium War, right? This was a time when the British government and the East India Company were basically glorified drug dealers, right? They were growing opium. They were growing opium in India. They were taking it to China, selling it in China in exchange for tea, which they then transported back to Britain. So there's a huge imperial history, right? Colonial imperial history around drugs in Asia and East Asia, right? The Hong Kong exists today because the British wanted to protect their trade in opium into China. The British went to war to protect the rights of corporate drug dealers, right, the companies that were trading in opium. They won the war, extracted concessions, including the right to govern in Hong Kong, right, which they exercised for the better part of a century, right? So, okay, so yes, there's something wrong, obviously, with executing drug dealers, obviously in one sense, right? But on the other hand, there's a history here, right? And once we start appreciating that, I think it's harder to be as absolutist as we are, right, about some of these things. So maybe that's a bit of a hedge in answering. I think there are all kinds of human rights that I think should be enforced, should be respected, but I also, I guess, have learned to have a little bit of maybe say humility or skepticism or something about being too absolutist in the way that I describe those rights. I'm not sure how this relates to my talk, but in any case, I guess I do think twice, put it that way. Okay, so on the international financial crisis, attempts by Europe and the EU to deal with the crisis, how it will affect Latin American systems. Wait, sorry, who is it that? Oh, yes, sorry. And I didn't catch your name the first time?
Alexandre.
Okay. So I'm not sure I have the tools to answer your question fully, specifically. But let me say generally that I think this is a real issue, and it's an issue that. So one of the questions that I've seen in the literature is this: if you use formal law versus informal law, which system is better for weaker states, right? Is it a system? Is it the formal international system where every state, strong, big or strong, has a place at the table and can express its views, right? Or is it an informal system, right, where smaller, weaker states, because these are not formal laws, are able to push back, right? They're able to say, oh, well, that's just informal law. Our formal state law says something different and gives them a stronger ability to resist. Now, I mean, Brazil's obviously a very powerful state these days, so I don't necessarily have Brazil in mind. I don't know if we would classify it along with, say, China and India as a generator of international principles, and therefore one of the states whose power needs to be resisted by smaller states, or in the context that you described, maybe it's trying to resist some of the imposition of norms. For me, the jury is out. I'm still not sure. I'm still not sure whether a formal state system is better for developing states. And I guess in some ways, I think this is really beyond my ability to say, right, as a lawyer. But I think these are very interesting questions from a sort of a political science, international relations perspective. I know there are lawyers who engage, constitutional lawyers who engage with these kinds of questions. I guess for me, the jury's out. I'm not sure, and I'd be happy to hear your perspective on this.
Thank you, Professor. No, because the international financial institutions, for example, Goldman Sachs, an example, that will deal with or have an agreement with, just because Goldman Sachs, for example, is an American one that is domiciled in Brazil, but because it's an American one, you have to comply with some American rules, for example, Dodd-Frank rules, even domiciled in Brazil. But maybe we are. This is it's a new issue here as well, because we are thinking that, well, maybe we have a lot of layers of the same law on the one, for example, international financial institution or one company in Brazil. That's maybe not good to us.
So sorry, just to respond, maybe it's an example of this earlier discussion,
Sure.
right? That we have international soft laws and informal regulation that then harden into state law, right? Now, if that happens, maybe it's easier for those regulations to be challenged constitutionally, right? Because you have a state actor to challenge, right? On the other hand, the more these soft principles migrate around the world and harden, then you have the sort of critical mass of laws which it becomes harder and harder to resist. But I'm not sure at this point that...
We may use the constitutional law, for example, in order to challenge this.
Yes.
This may be good.
Yes,
Yeah,
exactly,
yes.
exactly.
Yes.
But then, on the other hand, to the extent that around the world these laws get harder, right, soft principles get harder, then even though you might have isolated opportunities to challenge, maybe there's such a critical mass that the system sort of creates its own momentum.
All right. Thank you.
On Standard & Poor and other risk agencies, I think this is another good example, right, of transnational private transnational regulators that have an enormous impact. These are the kinds of institutions that, I can add those examples to my slide, and I think it would fit very nicely. The one that personally and professionally I'm also concerned with is university ranking agencies. And I'm sure deans of a lot of law schools and presidents of universities can tell you how powerful these agencies have become, right? So it's, one of my colleagues was trying to, I think he's still planning on doing this, but he wants to hold a colloquium on governance by indicators, right? And this is a sort of an example of private governance by indicators, right? So in the United States, okay, so this is just this is off the record, but it's on the record. But But you know, the U.S. News and World Report, right, the rankings of U.S. law schools, is probably the most powerful body in terms of how law schools govern themselves. I mean, that's my impression as an outsider, right? So much of the policy decisions of law schools is driven by rankings. The same thing's happening with universities, right? The Times Higher Education Supplement has universities. Those are the bodies that are in many ways generating policy decisions within universities. So that's just in the university context. But certainly, if you look at various indices, you know, whether it's in terms of health and education and economic performance and transparency, corruption, I think there's a real issue around governance by indicators. And this is, I guess, another example of the kind of transnational private regulation, right, that's having a clear impact on states, and yet, and clearly constitutional implications as well, because it's challenging the ability of states to provide services or govern according to their own interests and agendas, right? And yet, how do domestic constitutional actors respond? So this is exactly right. This is exactly the kind of concern that I have in mind. So thank you.
What about the reputation side
Yeah.
of the question?
Well,
So
exactly. And
they became so they became just so powerful that no matter what happens, they remain all that powerful, unharmed in their reputation. Is that all the
Yeah,
explanation for that?
Right, and that's, so when I talked about the tools that private regulators have, one is a market-based tool, right, which might matter if you're a private body, right, whether, I mean, even, you know, a private body that's trying to make a profit. If you have a good reputation, right, then your profits are going to go up. But also, even if you're a public agency or a government, right, you're concerned about your reputation, right? And so I think it can have an impact. These kinds of rankings and risk agencies and so forth can have an impact on the way both private and public actors conduct their activities and their affairs and make policy and so forth.
But I don't want to be to insist on that. But my specific point is their the agency's only reputation, because they fail.
Oh, I see. Okay.
In their
okay.
assessment.
Right.
Okay.
Yes. So they failed, and so their own. But then you'll have other agencies that say, oh, but we have a better system, right? And so it's a competition. Yes, it's a competition among agencies, and of course, that's what we see. Even, I mentioned the Forestry Stewardship Council, but there are other rival NGOs that are trying to regulate sustainable forestry. And they are also looking at their own internal procedures. Questions of legitimacy that I mentioned, how legitimate are we, right? Because the Forestry Stewardship Council has been criticized by some forestry product manufacturers in tropical countries as being too oriented towards Western interests, right? So then they say, oh, well, we have another set of regulations, and so you have competition among agencies, right? Saying, well, we're a better regulator, and maybe in the financial services sector as well, there'll be competition, right? Well, you didn't predict the crisis, but we can do a better job at that, and so you have some competition. Maybe that makes for better regulators on one level, right? Helps them to review their own internal rulemaking procedures and the information that they rely on to generate their standards. So maybe it does have some benefit in helping them to sort of self-correct. But then, as they do, maybe they become more powerful, right? As their reputation grows. So some reputations will be destroyed or damaged, and others might grow as a result. But I don't think that question, how that plays out, affects the more general proposition that these regulators are incredibly powerful, and what they say and how they publish their findings. I think it's clear that it has an impact on the way private and public bodies conduct their affairs. I think that's not disputable, even though in particular cases, yes, the individual reputations of private regulators, risk agencies might be affected.
Just a final observation. I've been listening here, and perhaps that should be a case to be considered. There is one of these international NGOs related to airlines, acts internationally and acts in Brazil as well. And they have a different system of rules related to interest rates, different for Brazilian companies and for foreign companies. So there is one interest rate for Brazilian companies, no matter if it's a good Brazilian company or not, and a lower interest rate for foreign companies. And well, that will be unconstitutional because it treats differently companies in Brazil just for its origin. But more than that, it's even illegal in Brazil because we have a limitation in interest rates, and their interest rate is more than the interest rate that is legal in Brazil. But they have been using this clause in their contracts for years, and no Brazilian company wants to challenge it. And even if one of the companies decide to challenge it, what happened a few months, perhaps more than a year ago, and that's how I got a contact with this issue. Their peers suggest them not to do that because they are afraid that this NGO just stop providing services in Brazil, and that would harm Brazilian companies from doing their jobs. So what seems for me is that they have a tool, a constitutional tool, to impose that constitutional limitation against a transnational private regulation. But it's ineffective. It's useless because it's just more than what a state can provide as a worldwide problem, as a market problem. So it's hard to imagine how to solve this question because they have the tool. The court, I'm quite sure that the court would declare that measure as unconstitutional and perhaps as illegal, but they just can't do that. How could we deal with this matter?
Okay, so two thoughts occur to me. The first is that I'm just going to ask the question. I'm not sure what the answer is, but I suspect there are similar issues domestically, right? I mean, so there are all kinds of calculations that will be made in terms of challenging domestic law that's potentially unconstitutional. There are groups who have common interests and might say, well, you know, it might be unconstitutional, but... So I'm not sure that that's a unique problem in terms of transnational regulation. But even if it is, I think that maybe this is where constitutional pluralism or, you know, the sort of multiple opportunities to contest laws may be helpful, because even if in Brazilian domestic constitutional law there are political or strategic reasons why it wouldn't be challenged, maybe there's another group, or maybe the same group, would be more comfortable invoking challenge at another level, in another forum, right, for making an attack or raising these issues. And then I guess the third point is that I think one of the arguments I will make in my last chapter is that I think we need to think of constitutionalism in a slightly different way, that as we are more flexible in terms of where constitutionalism may go, we might also think about constitutional actors, and it may be that we don't need to go to the court to raise constitutional issues. So we can generate a constitutional controversy in response by blogging, by going to the media, by, as an NGO, going to the offices of this company and lobbying, right? I mean, there are all kinds of tools that are constitutional tools that invoke constitutional principles and values that don't necessarily involve going to the court, right? And so, you know, people talk about the shadow of the law, right? Constitutionalism and the use of constitutional tools can take place in the shadow of the law, and I think that civil society organizations, NGOs, are probably more aware than most of us, right, of how this can be done.
Well, Professor Victor, it was really an honor for us to have you here for such a wonderful lecture. It's a lot of food for thought for many kinds of different scholars. I mean, globalization is creating a global agenda for legal scholars. So some years ago, the very title of your speech would sound strange for many people. When I was a student, I mean, a title like this, well, oh, what is this? And maybe it wouldn't call my attention, or maybe it would call it for the weirdness of it. But nowadays, things have changed completely, and we now see quite clearly how it's absolutely impossible for legal theories, for those interested in jurisprudence, constitutional law, commercial law, whatever, not to be in touch with what is happening in all these different areas. And I think your speech was wonderful in showing how this connects. And also it's wonderful to show the absolute importance of having in strengthening our connections with NUS, National University of Singapore. So we are really very glad to have you here for such a wonderful talk. And I'd like also to thank those who helped to organize this, especially Professor Francisco Satiro and Maria Eduarda and Sheila and all the staff, and also the audience, the faculty, and the students, of course. So thank you very much, and thank you again. Hope to have you soon here.
Thank you so much, Ronaldo. And just, I would like also to express my thanks to everyone, to Francisco, Ronaldo, Maria Eduarda, and all the commentators. This was incredibly enriching for me. I really appreciate, and all of the others who offered their comments and questions. I mean, when I present my work, I mean, I guess the one thing that I worry about is that, you know, either no one's interested or there's silence afterwards, and you've given me so much to think about, and I really appreciate all of the questions and all of the comments. You know, I'm here for I'm not sure what our plans are, but I will be around and be happy to talk to you informally later if you like. I'll stick around for a little while in case. But like you, I think that this just shows how important it is for us to connect institutionally, and I hope to see some of you in Singapore sometime. So I mean, it's a long way, right? But there is a flight. There is a flight, and maybe you took it, right? At one stop, Sao Paulo, Barcelona, Singapore. You know, so come out to Singapore and visit. And one more thing, I will have to virtually present my thank you gift to FJV. It's a copy of a book that I edited. It's called Emergencies and the Limits of Legality. It's sitting in my suitcase at my hotel, but I'm here for another day, so I'll be sure I give it to you later. So thank you very much.
Thank you.